So, a very good evening to all of the interns present here. And today we have amongst us Ms. Roopali Mohan, ma'am. She is the advocate at Delhi High Court and Supreme Court of India. And basically, she's a Delhi-based lawyer. So she has completed her graduation in law from Vivekananda Institute of Professional Studies, Guru Gobind Singh Indraprasth University, and Masters in Corporate and Financial Laws from Jindal Global Law School, both with distinction. And over the past 4 years, she has advised and represented her clients in civil and commercial litigation and arbitration, and she's also defended her clients in the financial crimes. She regularly appears before the Supreme Court of India, Delhi High Court, District Courts of Delhi, Gurgaon, as well as the Debt Recovery Tribunal, Central Administrative Tribunal, and Consumer Forums. We welcome you, ma'am.
Thank you, Riddhi. Thank you for the kind introduction and inviting me to speak today. Before we begin today's session, I just want to say I'm really impressed by how you guys spend your weekends in attending such lectures. I'm really delighted to be here and to be given this opportunity to speak on how to draft a legal notice in a check bounce case. So a check is a financial instrument. It's a very common instrument that we all have seen. In a check, the person who is basically issuing that check, that person is known as the drawer. He orders his bank to pay a particular sum of money from his account to the person in whose name a check is drawn. Checks are widely used in day-to-day transactions. We pay our bills, we pay under different agreements. Even a tenant can pay his rent by way of a check. So they are considered to be safer in the sense you do not have to carry cash everywhere. Check bounce was not an offense earlier. It was only in late 1980s that the Indian Parliament made it an offense to basically enhance the acceptability of checks and to ensure that the people honor their commitment to pay. So before we start today's session, I just want to know, is there any one of us who has never read Negotiable Instruments Act or is not aware about the law on check dishonor? It would be very helpful if you could please turn on your videos.
Ma'am, like most of them are freshers, so I'm sure they won't have read about the Negotiable Instruments Act.
Okay, then in that case, we'll start from the basics. So I think you all must be aware that serving a legal notice is not mandatory before we file a case. However, there are exceptions to this rule. The first rule is Section 80 of Civil Procedure Code, which clearly says that whenever you have to bring a civil action against the government, you have to serve a 2 months advance notice to the government. Likewise, Section 138 of the Negotiable Instruments Act also specifically says that before filing a complaint for check dishonor, you have to mandatorily serve a notice to the drawer of the check. I'll just share a small PPT. We'll begin with discussing the essentials of Section 138 of Negotiable Instruments Act so that we can have a basic understanding of the law. Then we'll discuss the essentials, the ingredients that are required to be there in a draft of a check bounce notice, and then we'll discuss a draft. Can you all see my screen? Can you see the PPT?
Yes, ma'am, it's visible.
Okay. So yes, let us discuss the essentials of Section 138 of the Negotiable Instruments Act. There has to be a check which is issued by the drawer, and then that check should have been for the payment of money in discharge of any debt or liability. It can be either in whole or in part towards the person in whose name that check is drawn. So this phrase, which is discharge of any debt or liability, basically implies that a debt or liability for which the drawer of the check is making the payment needs to have some sort of compulsion, some sort of an obligation under the law. So the payment should be such which can be enforced under the law. So suppose if A wants to give a gift to B of rupees 50,000 and he draws a check in favor of B, and that particular check gets dishonored. So B cannot bring an action against A because we know that transfer by way of gift is a voluntary transaction. You cannot compel a person to give you a gift. So only those payments would be acceptable that the person is under an obligation to pay. Secondly, such debt and liability must be legally enforceable. So again, you cannot bring an action in a check bounce case to enforce a liability that is not permitted under the law. You cannot ask a person to pay. You can if there's a check which is for any legal payment, so an action under a check dishonor would not be maintainable against such a person. There was this case wherein it was a rape case, it was a rape trial, and there was an agreement between the accused and the victim that the accused would pay a certain sum of money to the victim, and then they would enter into a settlement agreement and the victim would withdraw the case. So in pursuance of that settlement agreement, the accused basically issued a check in favor of the victim for a certain sum of money. What happened was later that that particular check got dishonored. So the victim brought an action against the accused, saying that he had to pay this money to me under the settlement agreement, and now that check has bounced. So I am bringing this action against him. So the court said that this is not a legally enforceable debt and liability. That was because Section 376 of the Indian Penal Code, which makes rape a punishable offense, is non-compoundable. So the accused and the victim cannot enter into a compromise, and therefore such a settlement agreement is bad in law. Such debt or liability arising out of such an agreement cannot be called legally enforceable debt or liability. So an action under Section 138 would be bad in law. The third ingredient is that such check should have been presented to the bank within 3 months from the date on which it was drawn. So the valid period in which the check is to be presented is 3 months from the date on which that check is drawn. Then the check was returned by the bank as unpaid. So if the drawer of the check does not have the sufficient balance in his account to honor his commitment to pay that amount which he has mentioned in the check. So in that case, the bank would issue a return memo and it would return the check to the payee. Then the payee has to make a demand by a notice in writing for the amount due to him or her under the check. Such notice should be served within 30 days from the date on which that return memo was issued by the bank to the payee. Then after the notice has been served, if the drawer fails to make the payment of the said amount of the money to the payee within 15 days from the date of receipt of such notice, then the payee can bring an action against the drawer in a check bounce case. So an offense of check bounce, so the cause of action in a check dishonor case does not arise merely because the drawer does not have sufficient balance in his account. It arises only and only after the check has bounced, the bank has intimated to you, and then you have served the legal notice, and then the drawer has failed to make the payment within 15 days of the service of that notice. Only then the cause of action in a check bounce case arises, and not merely because the bank has returned the check. So this is why a legal notice in a check bounce case is highly, highly important. Now let us have a look at the reasons why checks can be dishonored by the bank. The first we have already discussed, the drawer did not have sufficient balance in his bank account. In addition to that ground, there are several other grounds on the basis of which the check may get bounced. Second is signature mismatch. So suppose the drawer's signature on the check is different from the signature that is otherwise there in the bank's records. Then also the check will bounce. Then there's a mismatch of amounts in figures and words. Suppose the drawer writes in words that the check is for 5,000 rupees only, and in the figures he writes 5,100. Then the check will bounce. It would be another ground for check bounce. Then the check was presented after the validity period expired. So period for the check's validity period of a check is 3 months. And if you present it after 3 months, then also the check will bounce. Then again, if there is overwriting on check, then also the check will bounce. The drawer has to make sure that he neatly issues the check. And lastly, if the check is damaged, if it is torn, then also the bank will return the check. It will not pass that check. Now, since the essentials of Section 138 are clear, let us now, having understood why legal notice in Section 138 is important, that the statute mandates that you have to serve that legal notice. Let us now discuss the contents of the legal notice. You can jot these pointers down, or you can take a screenshot of this slide, because when we'll discuss the draft of the legal notice, we'll see how each of these pointers are incorporated in the body of the legal notice. So first is the name and address of the parties. You have to make sure that you write the name and the address of both the drawer as well as the payee of the check. Secondly, you have to write the brief facts. So you'll have to write how the transactions emerged between the parties, how the question of check came into being, and then how the check was drawn. You have to basically write the surrounding facts and circumstances in a brief and crisp manner to give a basic brief background. Then you have to write the check number, the date of check, and the amount of check. Check number is basically important to identify the particular check which was bounced. Date of check is important because that would ultimately prove before the court as well when the check was drawn and what was the validity period. That would show bona fides of the payee, that the payee presented the check within 3 months from the date on which it was drawn. And then amount of check. Amount of check is very, very important to be written in a legal notice, because in a check bounce legal notice, you can never claim an amount which is beyond the amount, that is any amount which is more than the amount mentioned on the check. However, there's a lot of lawyers claim interest amount or the cost of legal notice as well in their check amount, in their legal notice. That is okay as long as you are specifying the additional amount under different heads. However, once again, once the check, so suppose check amount is 50,000, you cannot write that, you know, your liability was of 50,000, the amount on the check was of 50,000, but now you are under an obligation to pay me 80,000. That particular legal notice will be considered as bad in law, and it can have serious repercussions. Even your complaint can get dismissed in a court. So it's very, very important that you make sure that the amount of the check is properly written and your demand is also specifically related to that particular amount. However, suppose the check amount is for rupees 50,000 and I make a demand of 65,000, but I specifically write it down. I categorically write it down that the amount of the check was for 50,000. So I am claiming that money from you. In addition to that, I am claiming 10% of 50,000 as interest, which is 5,000. And the balance of 10,000 I am claiming as a cost of this legal notice. Then that legal notice would not be considered as bad in law. What the court would do is it would sever that additional amount from the main check amount. And to that extent, your check would be considered as good in law. But anyway, you cannot claim any amount beyond that check amount. Then date on which the check was presented. You have to make sure that it was presented within its validity. Then you have to write place where the bank branch is situated. This is particularly important from the court's jurisdiction point of view. Then you have to write date of return memo and the reason for the dishonor of check. Date of return memo is important because you have to serve the legal notice within 30 days from the date on which you got that return memo, or date from which you got the communication from the bank that the check has dishonored. And in that bank memo only, it would be written why that check was dishonored. It could be either the funds were insufficient or there was a signature mismatch. So you have to write the reason. Then you also have to write violation of laws applicable. In a notice under Section 138, you have to specify that if the drawer does not make the payment within 15 days, then you will bring an action against him under Section 138 and even other laws that we'll discuss when we'll discuss the draft. And finally, we have to make a demand. We have to demand the drawer that you have to make the payment within 15 days. This 15 days period is specified in the statute itself. It's there in Section 138. So you have to make, so the drawer has to make the payment within 15 days from the date of receipt of the notice. So these are basic essentials of a check bounce notice that are required to be there. And now we'll discuss a brief draft of a check bounce case, so that you broadly get an idea how to go about it. And I'll first discuss brief facts of a hypothetical situation on the basis of which I've drafted that legal notice. So let us discuss that. So there were two persons, Mr. D and Mr. P. They had friendly relations. They were good friends. They had known each other for past few years. Mr. D was in dire need of money for his business, and he approached P for a loan of rupees 10 lakhs. D and P, P, considering the past relations with D, agreed to give the loan, and he executed a loan agreement, and P gave a loan of rupees 10 lakh to D in April 2021. D promised that, okay, thank you for giving me the loan. I'll repay this loan by April 2022, that is 12 months later. So in discharge of this liability, after a year, D signed and issued a check bearing number 123456 dated 1st of April 2022. This check was for the 10 lakh rupees loan that he had taken from P. Then P presented this check for encashment, but this check was returned unpaid. White check returning memo dated 10th of April 2022. So after 10 days of having received that check from P presented that check, and the bank returned that via memo dated 10th of April that the funds in D's account are insufficient to honor the payment in that check. So now suppose we are a group of lawyers and we have a law firm. So now P has come to us today on 24th of April 2022, and he is now requesting us to draft a legal notice and serve it on Mr. D. So I'll show you a draft of legal notice, how it is drafted, and then we'll see that all the ingredients that I had discussed in this particular slides would be incorporated in that particular legal notice. Just a second, I'll just share my screen. So this is a check bounce legal notice. You begin by writing by registered post, by speed post, email, WhatsApp. It's your discretion. Just make sure by any of the methods you serve that legal notice. Email and WhatsApp would be an instantaneous mode of service, and registered post and speed post would take a few days to get delivered. But then again, you have to make sure that when you file the final complaint, you put those postal receipts so that the court would know when the drawer finally received that legal notice. Then you will here write the date on which you are making that legal notice. Here you will write to Mr. D, who is the addressee of the legal notice, who is basically the drawer. In the instant case, you will write his residential address. Then we come to the subject. We'll write, this is a legal notice under section 138 of the Negotiable Instruments Act 1881. Then we begin with, under the instructions from and on behalf of our client, Mr. P, son of dash, and residents of this, you'll write the information of the payee here. So now we'll notice that we have written the name and address of both the parties in the legal notice in the initial part only. Hereinafter referred to as our client, we hereby serve upon you the addressee the following legal notice. First is that our client and you, the addressee, have known each other for the past 5 years and have been on friendly terms with each other. That due to financial losses, you, the addressee, was in dire need of money for your business. That you, the addressee, demanded a friendly loan of rupees 10 lakh, hereinafter referred to as loan amount, from our client in the first week of April 2021. That our client executed a loan agreement with you on 10th of April 2021. Hereinafter we'll refer to that particular loan agreement as loan agreement, and transferred the loan amount by way of RTGS. That as per the loan agreement, you, the addressee, have agreed to repay the loan amount by April 2022. So in first 5 paragraphs, we have in a crisp manner covered the surrounding facts and circumstances. We have covered the background of the transaction between Mr. D and Mr. P. Now we come to the details of the check. That you, the addressee, in discharge of your legal liability to repay the loan amount, issued a check bearing number 123456 dated 1st of April 2022 drawn on. Here you have to write the details of the bank. You write the name of the drawers bank, and as well as the name, as well as the place of the branch where that particular bank branch is situated. Of the loan amount, hereinafter referred to as check, you, the addressee, assured our client that the check would be honored. In terms of the above, our client represented the check to his banker, that is details of Pay's Bank. Now here you will write the name of Pay's Bank as well as the branch in which the Pay maintains his account. However, the check was returned unpaid, while bank memo dated 10th of April 2022, citing the reason for return to be insufficient funds. So now we have mentioned the details, the name and the details of both the drawers and the Pay's Bank, as well as we have written the details of the check, the date on which it was issued, the date on which the return memo was issued by the bank. So all those essentials are there in this legal notice. Now we are going to say, despite various reminders, if factually this has happened, you have to write, despite various reminders, you, the addressee, failed to make the payment to our client and have started to ignore the phone calls made by our client. This particular paragraph I have written because what happens in check bounce cases is people normally don't just go on and serve a legal notice right after receiving that communication from the bank. They always try to recover that particular sum of money from the drawer directly. They may even write an email to the drawer saying that, your check got dishonored, just rectify the error because of which it got bounced, and just allow me to get that payment. So first of all, there would be some sort of formal, informal communication between the drawer and the pay. So you can write that down here. Once the drawer is, if you are able to see that the drawer is reluctant or is not able to make the payment which is there of the amount which is there on the check, then you can proceed on to serving the legal notice. Then coming to para 9, that your deliberate act of not keeping sufficient funds in your bank account amounts to offense under section 138 of the Negotiable Instruments Act 1881, which is punishable with imprisonment up to 2 years and fine, which may extend up to twice the amount of the check. It further amounts to cheating under section 420 of the Indian Penal Code. So in 9th paragraph, we have covered the laws that have been violated by the drawer because of bouncing of his check. He can be made liable under section 138 and even section 420 of the IPC. Then, in the light of the above circumstances, we call upon you, the addressee, to make the payment of the dishonored check of rupees 10 lakhs within 15 days from the receipt of this notice, along with rupees dash. You can write any of the amount which you may want to recover for the cost of this legal notice towards the cost of this legal notice, failing which our client shall be compelled to initiate legal action against you as provided under section 138 of the Negotiable Instrument Act, and other civil and criminal proceedings against you at your cost, risk, and consequences. This notice is issued without prejudice to our client's other rights and remedies available to him under the law. So we'll write down the laws which have been violated while leaving scope for even other remedies that may be available to our client. Copy of this notice is retained in our office for future legal action. Then sincerely, you will put your signature, you will write your name, and you will write the name of the law firm if you're working with a law firm. So this is a very basic draft of a legal notice under section 138. You just have to make sure that all those pointers are covered. Depending upon the complexity of your case, you can, put in more details in the legal notice that you think is absolutely necessary, because once the drawer does not make the payment within 15 days from the receipt of this notice, then the payee has only 1 month of time from once these 15 days have lapsed, then from the last 15th day, the payee has just a month to file a criminal complaint under section 138 before a magistrate's court against the drawer. So it's a very time sensitive so the proceedings under section 138 are highly time sensitive, so you have to be very diligent, you have to be very aware, you have to make sure that you do not miss any deadlines that are prescribed under the statute. So depending upon the facts and circumstances of the case, you can mold your legal notice, but just make sure that all these basic details that we have discussed, that I read out, are covered in your legal notice. So since check bounce is a very basic proceeding, it's not that complex a case. This was it from my side, and I think I can take questions from you guys if you have any doubt on anything that we have discussed so far.
Interns, please feel free to ask your questions one by one. Or you
If
can
there's
even type out
anything
in the
that
chat
you,
box.
yeah, if there's anything that you haven't understood in terms of the statutory provision or the legal notice.
Anything? Don't you have any doubts regarding the legal notice or either the section check bounce? You can type out in the chat box. We can take 2 minutes. I feel they do not have any doubts. They've
I just hope
understood.
you all understood. Yeah.
They have understood because they were making notes out of it. So they have definitely understood that. So, okay, in turns, if you don't have any questions, then I would like to proceed with the vote of thanks. I, Riddhi Jindal, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to Advocate Roopali Mohan ma'am for taking out time from a busy schedule and actually disturbing her on Sunday. She took out time for all of you to have a session and train you for the legal notice under Section 138. It was a pleasure having you, ma'am.
Thank you so much for inviting me. You know, through these sessions, even we get to revise our basics just to, you know, impart this knowledge to everybody. So thank you for inviting me, and thank you all the attendees who came and attended this session. Thank you.
Thank you so much,
Thank you,
ma'am.
ma'am. Thank you, ma'am. Thank you, ma'am.
Thank you. Bye.